we give a bit of a background. Then we, on page 2, on page 3, we deal with the purpose of re-examination. Then on page 4, we deal with the nature of the evidence that the state seeks to re-examine the witness on. Then on page 6, we give an explanation as why the movement report was not presented when the evidence in chief was given by the witness.
Okay.
And lastly, we deal with the interest of justice. My Lord, coming to page 1, paragraph 1.1.
Yes.
We mentioned that the crisp issue at this stage of the proceedings is whether the state can be allowed to re-examine a witness by introducing the records of the automated vehicle location, what is also referred to as the movement report. Paragraph 1.2, we mentioned that insofar as may be argued that this is new evidence, the state makes a formal application to the court to be allowed to re-examine the Sergeant Mokhane on the AVL records. In paragraph 1.3, we mentioned that the defense put it to Sergeant Mokhane that on the 19th of June 2020, while he was transporting the accused in a Toyota Fortuner en route to Moroka police station, he took a detour and stopped at a place near a filling station, near a directional board to Alberton, where the accused was assaulted. They proceeded to a dumping area on the way to Alberton, where there were steel stairs and poles, where accused number 2 was further assaulted. That they thereafter proceeded to Chris Hani Baragwanath Hospital, where Lieutenant Colonel Rapadu was picked up. Thereafter, they proceeded to an empty space at Orlando, where there were disused ATMs, where accused number 2 was further assaulted. That Brigadier Gininda appeared with some documents, and the accused was forced to affix his thumbprint on them, and thereafter they proceeded to Moroka police station to complete the process, as the accused did not affix his thumbprints on some pages. Paragraph 1.4, we submit, my Lord, that these allegations are so serious that they ought to be investigated, and if the AVL records can assist the court in the determination of these issues, that it is in the interest of justice that this evidence be allowed at this point in time. Paragraph 1.5, we explain, my Lord, that AVL is a computer-based vehicle tracking system used to monitor the movement of vehicles in real time. It helps to determine and transmit the geographic location of a vehicle in real time, and we make the point, my Lord, that as it were, it's an eye in the sky. Paragraph 1.6, we make the submission that the AVL records will therefore show if there was any deviation along the route to Moroka Police Station. And we, in paragraph 1.7, we mention that the AVL records are therefore a silent witness. In paragraph 1.8, we argue, my lord, that it will not be necessary to await that a witness from the trekking company should testify first, as such evidence is usually given in a form of a 212 statement. In other words, just a formal statement stating that a tracking device was installed in a particular vehicle which provides vehicle location information, and that witness gathered or retrieved information from their system and would normally state that they attach the vehicle movement information for a particular period. And that's purely, my lord, to authenticate the movement report. And we argue here, my lord, that the Sergeant Mohani can authenticate this information as he was the driver of the vehicle in question and has testified as to the route that he followed, which is contained in the movement report, the AVL. We make the submission, my lord, that he can therefore validate the information provided in the AVL report as reliable. And we mentioned, my lord, that at this point in time, there's nothing that stops Sergeant Mohani from commenting on the movement report that we intend to re-examine him on. And we make this point, my lord, that even if it were argued that that it is hearsay evidence at this point, we refer to Section 3 of the Hearsay Evidence Act, subsection 3 thereof, which provides that hearsay evidence may provisionally be admitted in terms of Section 1B if the court is informed that the person upon whose credibility the probative value of such evidence depends will himself testify at the proceedings, and provided that if the person does not later testify, then such evidence can be disregarded. And we argue here, my lord, that and we've also indicated to the defense that this witness statement will be handed up in due course. And in under point 2, we deal with the purpose of re-examination. And we quote Section 1661 of the Criminal Procedure Act 51 of 1977, which reads as follows. And the heading there is cross-examination and re-examination of witnesses. We mentioned that under point 1, an accused may cross-examine any witness called on behalf of the prosecution at criminal proceedings, or any co-accused who testifies at criminal proceedings, or any witness called on behalf of such co-accused at criminal proceedings, and the prosecutor may cross-examine any witness, including an accused, called on behalf of the defense at criminal proceedings. And we put an emphasis on the following: and a witness called at such proceedings on behalf of the prosecution may be re-examined by the prosecutor on any matter raised during the cross-examination of that witness. And this is, my lord, the exercise that we're trying to embark upon. And a witness called on behalf of the defense at such proceedings may likewise be re-examined by the accused. Point 2, we mentioned that re-examination is the right which may be exercised when cross-examination is complete, as in casu, by the party who called the witness. The purpose of cross-examination is to clear up any point or misunderstanding, to correct uncertainties or wrong impressions which flowed from cross-examination, or to supplement something which did not come out fully. And here we refer to Himstra Criminal Procedure, the 2023 version at pages 22 to 61, as may have occurred during cross-examination. Under paragraph 3, we mentioned that re-examination is a useful mechanism to place a full and fair version of the witness evidence before the court, and thereby to get to the truth. And we refer to the case of Ramolope. The citation appears there. And under paragraph 4, this is now the basis upon which the current application is premised. New matters can be canvassed only with the leave of the court, which may allow further cross-examination on the new evidence, hence the state's application. Under paragraph 5, we submit, therefore, that no prejudice will be suffered, as the defense will be allowed to further cross-examine Sergeant Mokhane on the AVL records. Paragraph 6, we therefore request, with the leave of the court, to re-examine the witness, Sergeant Mokhane, on the AVL evidence. And, my Lord, we mentioned that the evidence will only be confined to the route traveled by Sergeant Mokhane on the 19th of June, so there was a typing error, should be 19 June 2020, whilst transporting accused number 2 to Moroka Police Station and thereafter to Vosloorus Court. Under paragraph 3, with the heading Nature of Evidence Sought to Re-examine a Witness on, we've already made the point, my Lord, under paragraph 3, that AVL is computer-based vehicle tracking system. We're not going to rehash it here. Under paragraph 3.2, the defense for accused number 1 and 2 objects to this re-examination on the basis that it's new evidence. And I suppose other counsel who might also. Under paragraph 3.3, we mentioned that the state contends that it is not new evidence, that now should read not new evidence, yeah, okay, as during cross-examination of Sergeant Mokhane, the defense put it to him that he was transporting accused number 2 in a Toyota Fortuner vehicle, and whilst en route to Moroka Police Station and eventually Vosloorus Court, he stopped near a filling station near a directional signboard to Alberton, and that they were joined by Constable Buthelezi and Mapumlo, who were driving a Nissan hardbody. That Constable Jonathan also joined them driving in his vehicle. That accused number 2, so the version goes, was then taken out of the Toyota Fortuner and put in the vehicle of Constable Jonathan. that accused number 2 was then placed in the right rear seat of Constable Jonathan's vehicle, and that the late Sergeant Mabena sat at the left rear seat and Constable Buthelezi stood at the right rear door next to the accused, and that Constable Jonathan pushed the driver's seat backwards towards the knees of the accused, accused number 2, and pressed the knees very hard. It was further put to him that the late Sergeant Mabena used a silver-colored Truett's plastic to suffocate the accused, whilst Constable Buthelezi was blocking accused number 2 from leaving the vehicle. Paragraph 3.4. It was put to Sergeant Mohani that from that place they proceeded with accused number 2 to a dumping area on the way to Alberton, and all the cars then stopped at that particular place, that there were steel chairs there with steel poles, that the hands of accused number 2 were handcuffed at his back, and were then, when they reached that place, they were taken off, and accused number 2's one hand was then handcuffed to a steel pole, and his jacket was then taken off. It was then put to the witnesses that the assault continued, and that accused number 2 was poured with water on the front part of his body, that Brigadier Gininda arrived in a white BMW with female Sergeant Mohola and another person in braces. Accused number 2 was then electrocuted by Sergeant Mabena, Constables Buthelezi and Jonathan taking turns. That when the plastic was removed from the face of accused number 2, he was bleeding from his nose. It was put to Sergeant Mohani that he did not participate in the assault at the garage or the steel place, but that he moved away when accused number 2 was assaulted, and came back and said, and we quote Yekelan Diman, we close quotation, paragraph 3.5. It was put to the witnesses that there was then a meeting, and they drove to Soweto, that Sergeant Mohani, accused number 2, and Sergeant Mabena drove into the premises of Chris Hani Baragwanath Hospital, where they met Lieutenant Colonel Rapadu. That Lieutenant Colonel Rapadu was with his wife and a child, and he gave his car keys to his wife. That they then drove with Lieutenant Colonel Rapadu to Orlando and stopped at an empty area where there were disused auto-teller machines. The cars were then parked, and accused number 2 was taken out of the Toyota Fortuner, and the assault continued. Brigadier Gininda then arrived with Sergeant Mohola and opened the boot of the BMW and sat on the edge. He took out certain documents and gave them to Colonel Rapadu, and accused number 2 was forced to sign those documents by affixing his thumbprint. And that's from the 16th of June 2020. The accused was not 2020. The accused number 2 was not in the right state of mind because of the assault. Paragraph 3.6. It was put to Sergeant Mohani that there were pages on which the thumbprint of the accused were not affixed. Hence, they proceeded to Moroka Police Station to complete the process. As already intimated, my lord, we make the submission that these allegations are so serious that they need to be investigated, and if the AVL records can assist in the determination of these issues, it is then in the interest of justice that the evidence on AVL be presented to determine if these serious allegations are true or not. And here, my lord, we're referring to the re-examination, that Sergeant Mokhane be re-examined on those AVL records. And under paragraph 4, with the heading explanation as to why the evidence was not led in evidence in chief. Paragraph 4.1, we mentioned that the AVL records were only received on Friday, 3 November 2023 at 9:47 after the evidence in chief of Sergeant Mokhane had already been concluded. And we attached the email from Brigadier Gininda in this regard. And we mentioned under paragraph 4.2 that the AVL records were immediately disclosed to the defense when they came to hand. Paragraph 5, under the heading the interest of justice. Paragraph 5.1, we respectfully submit that it is in the interest of justice to allow this evidence to determine if the proposition put to Sergeant Mokhane that he took a detour and stopped at 3 places to allow the accused to be assaulted is true or not. Then, my lord, we refer to the case of Hepworth that has been traversed in these proceedings. 1928 AD 265 at 277, where the court held that criminal proceedings are not a game in which one side is entitled to claim the benefit of any omission or mistake made by the other, and that the duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice was done. We also refer to the case of State versus Sheikh and others. We give the quotation there, where the court held as follows, and we quote, "The applicant stressed that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsection 35(3)(a) to O of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach. It is clear also that fairness is not a one-way street, conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused, as well as those distressed by the audacity and horror of crime. We also refer to the multi-choice case versus the National Prosecuting Authority and another. We give the citation there. Even if this case dealt with the right of the media to access the proceedings, the comments that were made by the Supreme Court of Appeal are opposite in this matter. And we give a quotation there in paragraphs 13 to 17. Our Constitutional Court has been vocal regarding the protection of the rights to a fair trial. Indeed, any accused person who appears in a court of law facing any charge has the constitutionally guaranteed right to a fair trial, which includes the foundational values of dignity, freedom, and equality, which are central to a fair trial. And in this regard, the Constitutional Court referred to the case of State versus Zukuza and others, where the court confirmed that the right to a fair trial is a comprehensive right and embraces a concept of substantive fairness, and that at the heart of the right to a fair criminal trial and what infuses its purpose is for justice to be done and also to be seen to be done. And we close the quotation. And we also refer to the case of Dlamini, Dlada, and others, Joubert versus Kittekat, to give the citation there. This case was given in the context of bail application. However, the remarks by Judge Krichler are opposite, wherein he describes what is meant by the phrase interest of justice, and he said the following, we quote, this is a useful term denoting in broad and evocative language a value judgment of what would be fair and just to all concerned. And we close the quotation. We therefore submit, my Lord, with respect that the state be allowed to re-examine Sergeant Mukhani on the AVL. I mentioned on Friday that the state may as well lead the evidence through other witnesses, but the fact of the matter is that Sergeant Mukhani will then have to come back to then give his comment on such evidence. We submit that the balance of convenience at this stage in the interest of justice, my Lord, will be served if Sergeant Mukhani is allowed to be re-examined on the vehicle movement report. Okay. These are our submissions, my Lord.
Thanks. Yes, Mr. Ngomezulu.
My Lord, firstly, my Lord, I wish to express my apology for my non-appearance due to the circumstance that I was not feeling well to come to court, my Lord.
Okay, fine.
Court pleases, my Lord, may I beg leave to hand over the heads of argument for in relation.
Yes, thank you.
Court pleases, my Lord, the heads of argument in relation to accused number 1 and 2, because that will actually even touch the movement of Mr. Mukhani in relation to accused number 2. They are structured in this manner, my Lord. Introduction, it deals with the gravamen of the objection or issues. My Lord, it has been submitted. We'll submit that the application by the state to re-examine Sergeant Mukhani on the evidence or on the document of an AVL does not find fairness and justice because he is not a competent expert in the field of the tracing and the tracking systems. Our heads of argument are structured as follows. Firstly, paragraph 2.1. There are two state witnesses which has testified about the escorting of Sergeant Mukhani and the late Sergeant Mabena to various places. Their oral evidence was not supported by AVL records, and as such, why would it be significant to re-examine Sergeant Mukhani differently from other witnesses who were escorting Sergeant Mukhani and the late, including the accused person? May I substantiate my argument in the following manner, my Lord? In this case, I would submit that the defense is relying on the submission made by the state in their heads of argument to the effect that the the reason for the recalling or tendering this new evidence is based on the version of accused number 2. The case of the state, my lord, is not founded on the version of accused number 2. This version is put to the witness to counter the evidence given orally by Sergeant Mokhane. And my lord, this is a documentary evidence which by submission was supposed to be discovered prior to the matter being set down for hearing and during the discovery of relevant documents. On paragraph 2.2, my lord, it is contended that secondly, the nature of the AVL records requires an expert who will be able to explain the synopsis, functioning, and the recording of the AVL system. Thirdly, the state has not laid the basis of the AVL's report, and the state has not established the agent who tracked the motor vehicle or the movement of the Toyota Fortuner as from the 16th of June 2020 to the 27th of October 2020 and beyond. The role of an expert witness and the evaluation of the expert witness. An article was drawn from Tools and Trade, headed 3rd March 2021. The expression expert witness is ordinarily used to refer to a witness whose opinion and the reasons on which they are based are admissible in evidence in litigious, technical, and scientific nature, enables such witness to draw inference and form views in circumstances where a court or a tribunal is unable to do so reliably unless it receives an assistance or guidance from someone with expertise on the relevant subject matter or in that particular field. My lord, it is further submitted that in case this proposition has been supported by R. versus Vilbro and another, 1957, Volume 3, SA 223, AD, page 228, from G to H. It was held that a party intending to call or calling a witness to give expert evidence of the kind discussed, he is required to furnish the other party with a summary of such witnesses' opinion and reasons thereof. In this case, my lord, nothing has been furnished to the other party as contemplated by or as provided in the case of R. versus Vilbro. I would submit further that before we proceed, the state, after having discovered this document on the Friday, which it has already submitted, was not a reasonable time for the state to produce such a document or to discover such a document, and as such, there is no summary of such witness in leading his opinion of the records. In the case of Schrader NO versus Automobile Association and another, Judge Davis also referred the well-known South African textbook of the law of evidence, Zephyr, in Paces and Skien, the South African Law of Evidence at page 330, where the learned authors thereof, citing the English judgment of National Justice Campania, Nivera, South Africa versus Prudential Assurance Company Ltd, outlines the duties of an expert as follows. An expert evidence presented to the court should be and should be seen to be the independent product of the expert, uninfluenced as to the form or content by the exigencies of litigation. In this case, my Lord, I would submit with respect that Sergeant Mogano is not a neutral person in giving assistance on the evidence of this AVL recordings, on the basis that he is a team investigating this matter, and his conclusions will always be biased. May I further make a submission in terms of the above mentioned case? An expert witness should provide independent assistance to the court by way of objective, unbiased opinion in relation to matters with his expertise. An expert witness should never assume the role of an advocate. An expert witness should state the facts or assumptions upon which his opinion is based. He should not omit to consider the material facts which could detract from the concluded opinion. An expert witness should make it clear when a particular question or issue falls outside his expertise. In the case of MTV versus MEC Health, the Pretoria High Court once again placed the issue of expert evidence firmly in the judicial spotlight. Focus was squarely placed on the requirement for expert witness to provide the court with an objective and unbiased opinion as possible, based on their expertise. What is common cause between the parties? There is a common cause between the state and the defense that the evidence to be led requires an expert evidence. Sergeant Mogane is not an expert in the AVL system or recording or systems, my Lord. They're supposed to be records. But for investigating team in the matter of Senzo Meyiwa under case number 636 of 10/2014. Submissions by counsel for accused number 1 and 2. It is submitted with due respect that the evidence of the AVL recordings does not exist in vacuum, that the kind of expert evidence requires an expert who is not biased and does not have does have an independent and impartial conclusion and inferences. As discussed supra, the tracking agents must assist the court with expert opinion which may be admissible as evidence. The expert to which the state has not convincingly brought, the evidence to which the state has not convincingly brought its case on the admissibility of confessions and of pointing out, it is my humble submission that the state case on the trial, within the trial, be argued and finalized after the testimony of Brigadier Gininda. There is no law available justifying the limitation of Section 35(1) of the Constitution and Section 35(5) of the Constitution for non-compliance with the provisions of Section 217(1)A, 217(1)A and 217(1)B, Roman figure 2, respectively. The evidence of any nature in these proceedings may be utilized in the main trial, and in the event the above honorable court find in favor of the state by ruling on the admissibility of the alleged confessions and pointing out, the expert evidence causes an unreasonable delay in the finalization of this trial within the trial. In conclusion, even if an expert can be called therein, there is no likelihood to assist the court drawing inferences, a reasonable conclusion on the face of the produced or discovered document or copies of the AVL records, dental reports. Furthermore, when looking at the AVL reports, it does not stipulate exact places where the said vehicle went and stopped at. My Lord, this is the summary of the heads, which I would like to beg leave, my Lord, to supplement in this fashion. In respect of the element of prejudice, it is my submission, my Lord, that the time in which this document is intended to be introduced by the state in these proceedings on its own is irregular, and the accused persons will suffer prejudice because the basis for which this application is made is to reintroduce an evidence to rebut the version of accused number 2. Accused number 2 will still come and testify if a need arises, and the state will have an opportunity to rebut the evidence that is placed under oath by accused number 2. My Lord, it is further submitted that one must look at the reasonable time, the reasons why it was not discovered timelessly. I would reiterate in my submission by saying, if an expert witness is called, firstly, to place the authenticity of the document before this honorable court, secondly, to assist the court in drawing inferences and conclusion on the recordings, it is of pivotal importance that any submission or any evidence given by the should not be given or should be given a preference to an independent somebody who does not investigate the matter. Hence, if Sergeant Mokgano has to give evidence or his view, that view cannot hold water in terms of the admissibility of such expert or of such recordings. My Lord, I would submit further before I sit that a judicial discretion is also required to be exercised when this application is brought, and to the extent that its nature, the nature of this application, must not be seen to delay the proceedings of this case. The reasons for saying that is because the state had an opportunity to investigate all the necessary information, either on factual base and on technical and scientific evidence that is purported to be used before this honorable court. And my submission further, my lord, is that it would be prudent if the court were to rule in favor of the state to recall the previous witnesses, Mr. Mapumulo and Mr. Sadike or Mr. Jonathan, so that their AVL recordings must also be brought before this court on record and must also be challenged. And furthermore, my lord, the evidence of this witness, to the extent of canvassing the logbooks and the pocket books of the witness, may also suffice in order to corroborate the evidence in which the state intends to lead this witness. Unless there's anything that your lordship wants me to address.
No, thank you. Mr. Mnisi?
As we have maintained on behalf of accused number 3, we don't have any submission to make which will abide by the decision of the court.
Okay, yes, thanks. Mr. Mkumalo?
My lord, I've prepared my heads of arguments. May I beg you to hand them to the court?
Yes.
My lord, my heads are not an objection per se, but
They're not?
they are not an objection per se, but I wish to render my services as an officer of the court.
Yes, good. I appreciate that.
I've also discussed my position with my colleagues.
Yes, yes.
Yes, thank you.
Okay.
I will start with the introduction, where I deal with the facts. Paragraph 1. During the trial and in the trial into the admissibility of a statement made to Lieutenant Colonel Rapad on the 19th of June 2020 and to the magistrate, Ms. Cronje, on the 24th of June 2020, pursuant to the provisions of the Criminal Procedure Act 51 of 1977, the state led the evidence of Detective Sergeant Mohane, who is one of the investigation officers. 2. The evidence of this witness is to the effect that he booked out accused 2 on the 18th of June 2020 to conduct an interview in the boardroom that will be at Valeria Police Station. Subsequent to the interview, he traveled with accused number 2 following his alibi in the company of the late Detective Sergeant Mapena. The copies of the occurrence book register, open bracket, SAP 10 close bracket, in respect of the accused 2 in this exercise were submitted, entered into the record as Exhibit NN. 3. Detective Sergeant Mohane testified that on the 18th of June 2020, when they were traveling with accused number 2 to his workplace in Carltonville, Rustenburg, and back to detain accused 2 when they received a phone call from Brigadier Geninda, who informed them that they had to take accused number 2 to Lieutenant Colonel Rapadu at Moroga Police Station for purposes of a statement. 4. It is common cause that they were traveling in a Toyota Fortuna with registration plate FV47LRGP, which was driven by Detective Sergeant Mohane. Detective Sergeant Mapena and the accused 2 were passengers. 5. The defense assertion is to the effect that the vehicle in which accused number 2 was traveling took various detours where accused number 2 was assaulted and tortured by various police officers and later made to sign a document, Exhibit HH, on the portions that were not signed at Moroka Police Station. 6. The issue for determination is whether the state can use the AVL record of the vehicle that accused who was traveling in re-examination of the witness for the first time when such was not raised under cross-examination. Under paragraph B, I deal with the applicability of law to the relevant facts. I deal with the provisions of the Constitution. 7. Section 35 of the Constitution of the Republic of South Africa, Act 108 of 1996, deals with arrested, detained, and accused persons. The provisions of Section 35(3), which deals with accused persons, provides as follows. Section 35(3). Every accused person has a right to a fair trial, which includes the right, small letter B in bracket, to have adequate time and facilities to prepare a defense, small letter I in bracket, to adduce and challenge evidence. C. The provisions of the Act, paragraph 8. The time-honored sequence of our adversarial system of cross-examination in chief, cross-examination and re-examination is enshrined as far as criminal trials are concerned in Section 166(1) in bracket of the Criminal Procedure Act 51 of 1977, which reads as follows. Section 166, which deals with cross-examination and re-examination of witnesses. Subsection 1. An accused may cross-examine any witness called on behalf of the prosecution at criminal proceedings, or any co-accused who testifies at criminal proceedings, or any witness called on behalf of such co-accused at criminal proceedings. And the prosecutor may cross-examine any witness, including an accused, called on behalf of the defense at criminal proceedings. And the witness called at such proceedings on behalf of the prosecution may be re-examined by the prosecutor on any matter raised during cross-examination of that witness. And the witness called on behalf of the defense at such proceedings may likewise be re-examined by the accused. Close quotation. Paragraph 9. The right of a party to re-examine his or her witness is therefore a favor granted by the court. Is therefore not a favor granted by the court, but a legal right, statutory entrenched. The accused is called to testify in a criminal trial, is a witness on behalf of the defense, and is entitled to rely upon Section 166, subsection 1 in brackets. Paragraph 10. As far as the right to re-examine the witness is concerned, the operative word in Section 166, subsection 1 in bracket are of any matter raised during cross-examination of that witness. Paragraph 11. 2 points emerge from an analysis of the quoted words. Firstly, there is a statutory right to re-examine on any matter if it is raised during cross-examination. These words of very wide compass, any being a word of wide and unqualified generality. See R. versus Hugo, 1926 AD 268 at 271. Paragraph 12. Secondly, the right to re-examine a witness on any matter is only limited to the extent that it was a matter raised during cross-examination of that witness. The contextual meaning of any matter raised during cross-examination of that witness cannot lead to misunderstanding. Paragraph 13. It will result in the absurdity that if any matter were raised during cross-examination in chief and the witness were cross-examined thereon, no re-examination will be permissible. This will be a denial of a time-honored rules relating to examination of witnesses acknowledged in our courts from the inception of the adversarial system. Paragraph P, the object of re-examination. At paragraph 14, generally speaking, the object of re-examination small letter a in bracket, clear up any point or a misunderstanding which may have occurred during cross-examination. Small letter b in bracket, to correct wrong impressions or false perceptions which may have been created in the course of cross-examination. Small letter c in bracket, to give the witness a fair opportunity to explain answers given by him under cross-examination, which, if unexplained, may create a wrong impression or be used to arrive at a false deduction. Small letter e in bracket, to put before the court a full picture and extent of facts elicited during cross-examination, or to give the witness an opportunity to correct patent mistakes made under cross-examination. 15. Re-examination can be and frequently is a very important mechanism for presenting a full and fair picture of the evidence of a witness and thus of arriving at the truth. Paragraph 16. After cross-examination has been concluded, the side that called the witness is given an opportunity to ask questions. This is done according to the rules which apply to re-examination in chief. Questions are limited to the field covered in cross-examination. Paragraph 17. If counsel wishes to deal with new matters that is not arising from the cross-examination, he requires the leave of the court. This is in nature of fresh examination in chief and gives the opposing party the right to cross-examine again. Paragraph 18. Re-examination is not limited to questions broached for the first time in cross-examination. In this regard, see State versus Ramalope, 1995, Volume 1, SA 616A at page 619 to 620H. Re-examination is a useful mechanism to place a full and fair version of the witness's evidence before court and thereby to get the truth. This was also said at State versus Ramalope at paragraph 620, sorry, at page 620, paragraph B to C. Prejudice. Paragraph 19. With regards to the test to be applied to an application to reopen, see Oosthuizen versus Stanley, 1938 AD 322 at 33, and Barclays Western Bank Limited versus Guinness and another, 1981, Volume 3, SA 91N at 95C to 96H. Paragraph 20. The consideration mentioned by the courts include the following: the reason why the evidence was not led timeously, the degree of materiality of the evidence, the possibility that it may have been shaped to relieve the pinch of the shoe, the possible prejudice on the other side, including such factors as the fact that a witness who could testify in rebuttal may no longer be available, the stage which the proceedings have reached, and the general need for finality. In this regard, see State versus Farfan, 1999, Volume 1, SACR 481 SCA, at 486, paragraph G to 487B. Conclusion. Paragraph 21. The provisions of Section 173 of the Constitution provide that the Constitutional Court, the Supreme Court of Appeal, and the High Court of South Africa each has the inherent power to protect and regulate their own process and to develop, taking into account the interests of justice. Paragraph 22. The role of a judicial officer is central to a criminal trial. The competency and impartiality of a judicial officer are substantive matters which affect and determine the fairness, in bracket, or lack thereof, close bracket, of a trial. Where there is a demonstrable lack of either on the part of the judicial officer, it cannot be said that the accused had a fair trial. It is appropriate to refer to a well-known dictum of Carl Lewis, J.A. in R. versus Hepworth, 1928 AD 265 at 277, regarding the role of a judicial officer in criminal trials. And I quote, A criminal trial is not a game, and a judge's position in a criminal trial is not merely that of an umpire to see that the rules of the game are observed by both sides. A judge is an administrator of justice. He is not merely a figurehead. He is only to direct and control the proceedings according to recognized rules of procedure, but to see that justice is done. My Lord, simply, there are two issues that I have raised in my head of argument.
Yes.
One is that if the state intends to re-examine the witness, Sergeant Mukhane, on the document, it has to seek leave from the court. Seek leave from the court to open the re-examination. Secondly, if it decides to call Sergeant Mukhane later in the evidence, it has to show that the evidence, why the evidence was not led timelessly, the degree of materiality of the evidence, the possibility that it may have been shaped to relieve the pinch of a shoe, the possible prejudice to the other side, including such factors as the fact that a witness who could testify in rebuttal may no longer be available, the stage which the proceedings have reached, and the general need for finality. Those are my submissions.
Okay. Any response, Mr. Baloyi? Oh, sorry, Mr. Mshalolo.
Thank you, my Lord. I've got no submissions, my Lord.
Okay, thank you. Sorry about that. I didn't see your head. Yes, any response?
As a court, please, my Lord, we just wish to respond to two issues raised by counsel for accused number 1 and 2.
Yes.
Firstly, he contended that the AVL report should have been disclosed right at the outset when the rest of the statements were disclosed. My Lord, the version of the accused was only put during the trial, within the trial. Before the matter is enrolled, we only sit with confessions and pointings out. We don't know what the version of the accused is going to be. We don't know whether there's going to be a trial within a trial. So the state only became aware of what the version of the accused is during the trial within a trial. The second point relates to expect evidence, and this is stated in page I think it's page 3. In conclusion, Advocate Ngumazulu makes the point that if an expert witness can be called, there is no likelihood to assist the court in drawing inferences or reasonable conclusion on the face of the produced or discovered copies of the AVL, or I suppose the inclusion of dental reports was a mistake, as we're only dealing with the AVL. Fact of the matter is, Sergeant Mukhane is here. He's able to comment on the AVL reports, and Advocate Ngumazulu on page 2 of his heads made the point on expect evidence, its role, and how it should be approached. And my Lord, in this instance, one wonders whether one can regard AVL as expect evidence in the traditional sense of the words, because these are just a report on the movement of a vehicle. It is as it were, a fly against the wall that monitors the geographical location of a vehicle. We've indicated what the nature of a statement will be from the company that installs the device. So, my Lord, it's just merely a report, that helps to determine where a vehicle was at a particular point in time. And as we've indicated, my lord, Sergeant Mokhane was the driver of the vehicle. He's able to tell this court as to which route they traveled. This AVL report is merely supplementary to indicate whether the evidence of Sergeant Mokhane is correct or not. Thank you.
Thanks. What's your time there?
11:34.
Hello?
11:34.
11:34. Okay. Let's go out for 15 minutes.